The Supreme Court appears divided over how to handle a rare capital case concerning death row inmate Richard Glossip, who has unusual support from Oklahoma's own Attorney General Drummond. The case revolves around allegations that prosecutors suppressed key evidence and allowed false testimony from Justin Sneed, the primary witness in the case, who implicated Glossip in a murder-for-hire scheme. Sneed, who admitted to killing Barry Von Treese, received a life sentence in exchange for testifying against Glossip.
The state has one indispensable witness. That witness is Sneed. He's the person who committed the murder. He's the person until the police talked to him. Glossip was only charged as an accessory after the fact, so there's every indication this is the absolute critical witness. And if that witness lies on the stand, perjures himself on the stand, that seems to me that could have a reasonable probability of leading to a different result.
During oral arguments, the justices debated whether Oklahoma's failure to disclose Sneed's psychiatric treatment and false testimony violated Glossip's due process rights. There also appeared to be some support for sending the case back to the lower courts for further evaluation. Oklahoma Attorney General Drummond, a Republican who believes Glossip did not receive a fair trial, was present during the session and has said it would be a, quote, travesty if the court allows Glossip's execution without a retrial. Some of the court's conservative members cast a more skeptical tone over Glossip's case. Chief Justice John Roberts questioned whether Sneed's undisclosed psychiatric history would have made a significant impact on the jury's decision. And Justice Samuel Alito gave strong credence to the Oklahoma court where Glossip was convicted.
The issue is one that could have been presented previously because the factual basis for the claim was ascertainable through the exercise of reasonable diligence. And then it goes on to the innocence requirement. And the facts are not sufficient to establish by clear and convincing evidence that but for the alleged error, no reasonable fact finder would have found the applicant guilty of the underlying offense or would have rendered the penalty of death. What's ambiguous about that?
Meanwhile, Justice Ketanji Brown Jackson suggested that further review of the new evidence might be warranted.
There seems like there's some pretty significant factual questions that have been debated. What did counsel know? What did these notes markings mean? Was Sneed's statement that he never saw a psychiatrist true or false? Would you object to an evidentiary hearing? As I understood it, no court has ever actually made findings on those things.
The case also raises thorny issues surrounding federalism and whether the Supreme Court really wants to intervene in a capital case that was decided at the state level. A decision is expected in the coming months. I'm Kalen Deese for Washington Examiner.